everybody. Thank you very much for joining us. The focus of today's topic is how to reform India's criminal laws or how not to reform India's criminal laws. If this is a story that hasn't passed your feed, just in a very short, the Home Ministry has set up a 5-member all-male committee to suggest how to reform India's criminal laws. I'd also urge you to look at a video where we've gone into nuts and bolts as to what really is at stake here, what's the problem here with this 5-member committee. There are actually just two ways, in a sense, to see this story. Number one, that here's a government of the day that has finally chosen to take on a job that is long, arduous, and complex, and has decided to reform India's age-old criminal laws. The second way to perhaps look at the story is, yes, we all agree India's criminal reforms do badly need reform, but if the process is not transparent, if it's not inclusive, if it's not diverse, we could end up causing more harm than good. Helping us understand this process are two lawyers, Anubha Bhonsle and Jawahar Raja. Thank you very much, both of you, for joining me here on Newsworthy. I'd first like to ask, Jawahar, I know you've chosen not to be part of the process, and Anubha, I know you've chosen to register at least for this online process, but haven't contributed with your suggestions or thoughts. Anubha, would you like to go first and explain why?
So when I learned about this whole process and the committee, I was curious to see what are they doing and what really is happening there. And therefore, I registered without really sort of thinking about how this process is going on. When I registered is when I saw that there are questionnaires that they had put out to one at that point in time. And I realized, especially by looking at the questions, that this really needs a lot more discussion. And it's not something that can be done in a question answer form like this. At that stage, in fact, they had a 200-word limit, which I thought was just appalling for the kind of questions that they were asking. They did change that later. So I registered only to find out, what's really happening, what's the kind of information that they are sharing on their website and sharing exclusively with the people who have registered as experts.
Jawahar, right? Why did you choose not to be even part of this process?
So like you mentioned, Anubha, and as the other Anubha said, that when the news of the setting up of this committee filtered out, I initially received it with some enthusiasm because we know that there are many aspects of criminal law that need reform, right? And we've been part of several campaigns, several letter writing, memorandum, and so on about why and how the law needs to be reformed. And so one was actually enthusiastic that this process was afoot. One was even happy that it would involve the university as well, where perhaps there would be the possibility for deep engagement and deliberation. But soon after that, when one began to see the context in which this enterprise had been set in motion, and when one discovered what was on the website of the committee, that they intended to do all of this in 6 months' time. And I mean, shockingly, that they were going to rewrite all of Indian criminal law, and there was not a single woman on the committee. There didn't seem to be anybody representing the over-policed and the people who are facing the brunt of the criminal justice system. Didn't seem to be represented at all in that committee.
I'll just interrupt here because I want to get into the composition and all of that. Right. That sort of comes under one section. And I'm going to sort of be the advocate on the other side because we don't have a member of the committee yet on this panel. The thing is that it's not clear what's going to come after the deadline is over. If the government of the day was to argue, if the committee was to argue, as I see they have argued in some interviews, this is a first process. What's really wrong with it also just coming up with a framework on which further deliberations have to take place? Right.
So let me just conclude. So when I saw what was at stake and I saw what was the process which they had in mind, it seemed clear to me that this was not a completely innocent exercise, right? That it was set in motion with a certain specific agenda, and whether the members of the committee see it or not, it is part of a larger process by which India's what remains of Indian democracy is sought to be completely whittled down.
What is the agenda? What is the agenda as you see it?
No, so to get to your second question about perhaps this is just the first step. Well, as a first step, even as a first step, there have been several, as the committee notes, several law commission reports on several aspects of the criminal law that need reform. Right? Several civil society reports and well-argued reports about what needs reform. The first step of that process would have required the committee to put its mind together to identify what are the issues that need reform and how is it that we're going to apply our minds to it and what is it that we're going to focus on, and then to start the process of public deliberation. This doesn't seem, from what is afoot, it doesn't seem to be the first step in the process. This seems like the penultimate step. It seems as if they have put together on their website 76 law commission reports, articles by one of their members, and at the end of it, they've set out a series of questions which seem like the most degraded form of Twitter sort of polling, where people are asked to write in with a yes or no sort of question. They have removed the 200-word limit, but in effect, the questions are about that. Do you think this needs reform? Do you think that needs reform? If yes, how? And if yes, no. Clearly, this is not either. If this is the first step, then this ought to have been designed as a first step, which is to first do a detailed analysis of the state of the law and the state of the implementation of the law, to then open up the process to invite people to then participate in a more. This seems to be that it doesn't seem to be the first step. This seems to be almost like the penultimate step.
Okay. Anubha, you've been sort of part of the process in the sense that you have a sense of what's being asked, etc. And I know Jawar's sort of taken us right into the meat of what's being asked or what's sort of going to be reformed. Give me a sense of what he's talking about. What is the problematic questions that are being asked and why are they problematic?
Just to also just contextualize that, there are 6 questionnaires, right? All 6 of them have not been released together. When we practice criminal law, we look at the 3 components of criminal law. That's the Indian Penal Code, the Criminal Procedure Code, and the Evidence Act together. So if when there is any reform process or any question even, where we are looking at even an interpretation, even when we argue a case of a particular provision, we do end up looking at all 3, if not more.
Sure.
Right? So in this manner, where the process itself is that they are releasing questionnaire by questionnaire, one doesn't even have visibility on what's the next set. Are they asking the consequential questions of whatever they have asked in the substantial criminal questionnaire? So for example, and here I come to some of the examples which are very, very concerning. One of the questions in the initial questionnaires on the IPC, on the Indian Penal Code, was whether rape laws need to be gender neutral. First of all, a question of this nature cannot really be a question like this. It's a long drawn discussion. There are too many pros and cons to a provision on sexual violence being gender specific and or gender neutral, whether it needs to cater to specific genders in different languages or in different use of words. There is a lot of aspects at play here. Yes, and like I said, that cannot be in a question answer form like this online. And then one doesn't even know what are the consequential questions to that in the procedural aspects, in the evidentiary aspect. Now, when we look at all the 6 questionnaires, we have some sense of, okay, there is some link, but it's still not enough. For example, in the questionnaire on evidence, now there is one question on should the level of evidence required for proving a marital rape be different, from any other. But again, now, how does one really respond to something like this in the manner in which they are doing this, in the time limit in which they are doing it, without really consulting, without speaking, without understanding the ground realities of stuff like this? Another example that I'd really like to give is, for example, there is a question on the decriminalization of abortion, which is section 312 of the IPC. Now, that's a whole bunch of sections, 312 to 316, which, when we do talk about decriminalization of abortion, need to be relooked. And we know that abortion in this country is conditional in the sense that only there is an exception to 312 and comes under the MTP Act. So again, you can't look at 312 IPC in isolation. You have to then think about, okay, what will happen to the MTP Act? What will happen where you still say that, what about the fact that the Supreme Court has already articulated that a woman has, or a pregnant person has, a right of autonomy over his or her own body, which includes whether a pregnancy needs to be continued or not. How can you lose sight of that when you are looking at reforming criminal law specific to continuation of a pregnancy or not?
Let me get sorry, do you want to complete that thought? Complete that thought.
No, so that's the point, that these are just two examples, but there are so many, not only on the substantive criminal law in the sense that what will be punished, what level of an commission or omission will be punished, but it also percolates down to the procedural, arrest, bail, confession, the kind of evidence that is required, what's the value of a dying declaration, for example.
Push those examples further and connect it to the dots that Jawahar was saying. Why are all of these examples leading us to believe that there is a predetermination of what needs to be amended? This could just be a gathering of thoughts. Why are we using the word agenda, or why are we thinking that there is a predetermination? We already know what's going to be amended, and the committee is actually working, or the tonality of the questions is in that direction. Do you want to take that, and then Jawahar can take it quickly?
Okay. So from where I look at it, the extreme hurry for lawmaking that this regime has brought in, which, I mean, yes, I understand there is a lot of law reform that is required, that needs to be done. But there is a manner, there is a process. Yes, the process needs to be bettered, but it can't be in such a hurry. And that too during a pandemic, when you know that most people don't even have access to their livelihoods. You know, most lawyers are unable to make ends meet. And in that situation, you are asking lawyers or legal professionals or persons connected with the law to respond to a whole set of questionnaires online in English, which really requires a lot of reading. I mean, if you pick up even one question, you can't just answer it based on your own practice and your experience. You have to refer to criminal law books and other judgments. But having said that,
let me get Jawahar to answer that thread. I mean, why are we still sensing that there is a predetermination? Because many laws in this country are undergoing some kind of reform. You have an environmental impact assessment, you've had the mining, everything is being sent out for suggestions. And I think when we put out a similar report detailing about 6 and 7 laws where the government is asking for some kind of suggestions, you know, the argument from the other side is that they're getting on with the business of governance, however flawed it may be procedurally. Jawahar, I want you to answer that question as to why are we sensing that there is a predetermination?
So when the question of what the process is about and why this process has been set in motion was put to the chairperson of the committee by the news magazine Frontline, he said that it was because it was meant to rewrite the laws that were written in colonial times. Right? This is a person who is the vice chancellor of a university. He cannot not know that the entire process of rewriting all of these 3 laws in keeping with the constitution and in keeping with the developing constitutional jurisprudence had been undertaken and completed by all the law commissions. In 1979, Upendra Bakshi wrote a detailed critique of the functioning of the law commissions. There are many problems with the way that functions, but even in that he notes that the process of modernizing these 3 laws has been completed and concluded. Clearly the vice chancellor knows this. This is the chairperson of the committee. The home minister announces in November of 2019 that this process of rewriting these 3 laws must begin now because these are colonial laws. Perhaps the Home Minister does not know this, but the Vice Chancellor certainly knows this. At the same meeting where the Home Minister announces the rewriting of these laws, he lauds the UP government for its law and order improvements. Right? And we know at that time, the UP government was neck deep in allegations about the use of encounters as a law and order solution. Encounters fundamentally are anti-democratic, anti-constitutional. And therefore, if it's okay if the Home Minister does not know that this has been done, certainly the Vice Chancellor knows this. So for a university to take it up is it not incumbent on them to understand the fact that, look, this so-called, that the whole premise that the ministry is coming at it is mistaken and faulty? Yes, even after the process of modernization, there are things that require change, and therefore we need to focus on what it is that is specifically to be done. So then you look at what is the procedure which they're intending to follow, to see whether perhaps my sense or my inkling that perhaps this is motivated is actually answered. And then you see that they intend to do this entirely in 6 months' time, and they intend to do this in the middle of a pandemic, right? And as Professor Ramguha said, a pandemic is no time to be doing law reform. 75,000 Indians have died since March of this year, right? And this is coinciding with the time when this law reform exercise is happening. Clearly, if you intended to rewrite laws and to rewrite it in keeping with the requirements of modern times, then you will do it in such a fashion that people are able to participate and actually challenge each other's perspectives. As Anubha said, when it comes to gender neutral laws, Anubha and I might come from different perspectives.
Yeah.
The need of the hour is to set up a committee that is able to allow for public deliberation about these different perspectives.
Jawad,
And allow for that.
I have two questions that come from that. Do we understand as to why this particular university has been chosen and tasked with this mandate? Is there anything we know as to why?
There seems to be, so far in the material has been put out by either the committee or by the Home Ministry, there's no indication at all. The chairperson obviously claims that they have great research and resource facilities, although from the website of the committee itself, that doesn't seem to be the case, because the only resources that have been put up are 76 law commission reports and 35 articles by one person who is a member of that committee. So I don't know why this university was chosen over several other universities. Why was it not given to a conglomeration of law faculties? Why was it not given to the Bar Council of India? Why was it not given to the Law Commission of India? These are all questions which are unanswered, which seem to, again, if the Home Ministry has picked and chosen these 5 persons and not 5 others, and picked and chosen people who are from a very narrow social band, this seems to indicate again a pre-ordained conclusion.
So, Anubha, I'm sort of going to take the crux of all of that Jawahar has said. So, so the suggestion would be the fact that the committee is just 5 members, the fact that the committee sits in one particular university, is all male, is online, is English, does not have, let's say, gender minorities or vulnerable communities or marginalized communities. And to some extent, its mandate is also not clear completely as to what are we going to have once the October deadline ends. Are we to believe that all of this, and I think important also to underline that the fact that this sits under the Home Ministry and not the Law Ministry, is making us feel that there is a predetermination of what needs to be amended or what the government wants amended?
See, I think it's all of that, but it's also the history of this government. I mean, we're seeing every day that new people are getting arrested. Laws are being misused in a manner to just keep bringing more and more people who criticize the functioning of the government in any form within the criminal justice system. And then when you look at the kind of questions that they are asking, they are do you think should it be reformed kind of thing. So one would unsuspectingly think that, oh, this is, I mean, they're asking my opinion. But we don't know how many people are opining what. Are they going to give out the statistics? Do we know how many people have registered? How many people like me have registered but not answered? You know, if people have answered, are we going to see some trends? Are they going to share statistics? So for example, if the question is on gender neutrality of the sexual offenses, are they going to tell us how many people said yes, how many people said no? Are they going to give us a crux of what was the reasoning? We don't know anything. I mean, we all could probably participate. Maybe we all could participate and say put all the correct perspectives in a sense before them. But we don't know what they are considering. On what basis are they going to reach the conclusions that, it does appear increasingly that they've already reached.
But Anubha, if I was to just push that point further and sort of be the devil's advocate in that sense, the fact that we don't know what's going to be the end result is also perhaps a reason to participate in the process and see what the end result is. If the end result is an indication that we tried out this process and this is the framework of the responses and we are going to build on it, what's wrong, some would say.
See, so, and that's where I come back to what Jawahar was saying, that for example, if this was an exercise taken up by, say, the Law Commission, or say the National Commission for Women, etc. I mean, all these are statutory government bodies. Anyone and everyone through procedure has access to the documents that they rely on, the submissions that are made to them, the reasoning that has gone behind. One can even participate in the discussions that take place either as observers or as a participant. We don't know anything about the manner in which this particular Criminal Law Reforms Committee is functioning. Apart from why them, we don't know, why can't they even at least put out what the procedure is? How have they come to the questions that they have come to? How are they going to determine, for example, on a response, there are 50% people who have replied saying X and 50% have said Y. How are they going to decide X or Y? What is the importance that they are giving to the opinions that they are soliciting? And then they have this entire process of open consultation, which is, I mean, it's just, give us links to any articles or any research papers done, which is, I mean, anyone could have done that, frankly, if you just do a Google search. What are you going to do about those open consultations? Why are you resisting addressing the concerns that have been raised right at the very beginning, even before you started the whole process? One is completely unable to understand that.
Jawahar, I have two questions. If I was to ask you to just, and I know it's unfair, to leave the pandemic aside, something like the Justice Verma Committee, I know its scope of work was sort of limited in that sense, also came out with what it was mandated to do in a period of about a month or so. So just the time frame aspect of it, maybe the government has not come out transparently to say what it wants this committee to do, but maybe its scope of work is limited, and 6 months we'll see what the result is.
So there were deep problems also with the way the Justice Verma Committee went about its process, and let's not sort of valorize that as a gold standard. Right? So when it comes to law reform, there is now globally evolving a protocol of how law reform can be done and should be done. And if you see even the law commissions, there are good law commission reports and bad law commission reports. The first law commission of India, for example, went through a detailed process of deliberation in which it sent out 6,000 questionnaires. This is back in the late 50s, right? 6,000 questionnaires were sent out. They went and visited several high courts, took opinions from several bar associations, and took public evidence from people who wanted to come and testify to them about what needed change in the law. That's one process of, that's one way of how it could be done that was set in motion in the late 50s. The South African Law Commission as well has a detailed protocol of how these things can be done. Let's be clear that the focus is not on, is 6 months enough, is 1 year enough, is 2 years enough. The focus is on what is the procedure and how is it you're going to go about it. If, for example, you're looking only at the issue of gender neutrality, perhaps 1 month is enough. I don't know, perhaps it's enough. But then it is about in that 1 month, what is it you're going to put in place and how is it you're going to examine. Did I lose you all for a minute? Yeah. So it's going to be about how you all are going to examine, and go about this whole procedure. That seems to be what is most seriously lacking in this whole exercise. Right? The fact that you would have to put out first a discussion paper on these are the aspects that we've identified with the IPC that need change. Instead, what we had was the objectives that were put out. The objectives were everything and nothing. For example, in the IPC, the objectives were that we are going to examine actus reus and mens rea, which are basically the foundation blocks of criminal law. Right? And we're going to look at exceptions to actus reus, mens rea requirements. Now, that is all of the IPC. That tells us nothing about what they intend to do and what they're going to focus on. When the first response to the commission, to the setting up of the commission, was a letter from 16 retired judges and lawyers, where they asked many very simple questions. One, give us or make public your terms of reference.
Yes.
Two, tell us whether your report, a draft report, will be sent first to the ministry, And will your report be finalized under the guidance of the ministry? Right? Till today, they've not answered that. Therefore, our concern that no matter what report the draft might look like, the final report is going to be at the dictates of the ministry itself. If the committee cannot even today say that no, we are going to send our report irrespective of what the ministry says, then clearly they're going to follow the dictates of the Home Ministry. And also the judges asked that, look, all responses that come to you, please make them publicly available and place the draft report in public and give the public 1 month's time to respond to the draft report. Right? None of that has been responded to. Instead, what you have, what came out of the committee was immediately a series of pious pronouncements about how, oh, we're going to follow the all democratic principles and we're going to adhere to all principles of good conduct in conducting this law reform. But there's the pandemic. And therefore, we cannot do X, Y, Z things, which begs the question, then why press it during the pandemic? If you cannot do a decent law reform exercise, why press it during the pandemic?
Okay. So, I mean, I think we've covered all ground, and I think you've also indicated as to how every group, whether it's civil society, whether it's jurists, whether it's women lawyers, whether it's marginalized communities, have all sort of raised the red flag. Now, from all that we know so far is, I think, 1 to 2 public interviews that members of the five-member committee has given. And I mean, I've read them out sort of repeatedly to see if there's any indication of what happens or how this criticism is being taken. Looks like it's unaffected, right? So the committee is very much going ahead with its work. I think it's also important to point out that that 5-member committee, I think all members are currently part-time. So they do have other things to attend to. They do have other jobs, and they're also tasked with this process of giving suggestions to reform India's criminal laws. Jamar and Anubha, just quick last comments. So from whatever we've heard from the committee, they are going ahead. What happens after the deadline is over? What would counter look like if in the next 2 months you have a draft committee report that's either submitted to the Home Ministry, maybe it's put in public domain, maybe it's not put in the public domain, we don't know. What happens from there? Anybody first?
Yeah, I think, I mean, see, the expectation here is that this would then take the course that any other law reform process takes, which is that they will be expecting, I mean, they'll put it out in the public. So once the committee gives its report and gives it to the ministry, then the ministry is bound in law to put out the suggestions or put out the draft amendments in public for, public consultation, for inputs, for questions. And then once that is done, they will then either, re-amend the amended portions, etc. And then it'll probably be placed in the parliament is what my sense is. So, I mean, the hope here is that between that, there will still be some space for more interaction, for pushing, for really figuring out what it is that they are changing, how much are they changing, what are the implications of changes of this nature. And then really, like any other law reform process, one would have to advocate with stakeholders concerned.
Jamar, do you want to add final comments as where do we go from here?
Perhaps a good historical precedent would be the Malimat Committee report,
yes,
which went through a whole 2-year process by which they went to different parts of the country and elicited opinion and so on. And yet, even there, what they did was they took what suited a purely law and order centric, anti-democratic aspects of a law and suggested law reform. So, for example, where suggestions about how the burden of proof ought not to be tampered with were placed, with historical experience of how it has worked to ill effect in other parts of the world, the committee took those experiences and suggested that they may be made part of the law. Importantly, the Malimat Committee report was met with a furor from civil society, and people attacked it and showed it for the poverty of its reasoning. Right? And I think, therefore, what happens after this report comes out, Anubha's outlined for us what happens in the legislative sphere, but I think for us as civil society, we must be clear about what our job is. that this public deliberation, which has been denied us by this committee, begins after this report comes out, where we know for a fact that, or at least we apprehend, and with good reason, that the laws are going to actually work serious harm to India's constitutional setup. And therefore, it is for us then to attack it and critique it and to show how unreasonable it is. And let's remember also that right now, perhaps the voices that are raised against the committee are people from a particular political sort of persuasion.
Yes.
But these laws are going to work harm against all sorts of people and are going to strengthen the hands of whoever holds power. Power is notoriously fleeting, and once it passes from the hands of those of our current political masters, they will be used by the next dispensation. Therefore, it's important that this sort of like concern about civil liberties, not civil liberties and political liberties, not even broader socio-economic concerns, is internalized. And I think people should wake up and realize that this is going to be used against you, me, and anybody else.
Yeah, and therefore not see it from a political lens. But so far as the committee is concerned, its working is concerned, its composition is concerned, how it's gone about working during this pandemic, it's pretty much looks like a fait accompli. Jawahar Raja, Anubha Rastogi, I'll have to leave it here, but thank you very much for joining this and putting all of this in perspective.
Thanks, Anubha.
Thank you.